I've been asked to speak tonight on the subject of when is the appropriate time to hire an attorney. In 1775, the conflict between the American colonists and Great Britain had just reached a fever pitch. While many in the colonies were convinced that the agreement between them and the British could still be made, the stubborn British government rendered the chances of making that agreement seem more and more remote by the day. Repeated attempts to settle the Americans' disputes had been met with derision and mockery. Just a few short months earlier, none other than Benjamin Franklin had been sent to negotiate for the colonies, but when he got to London, the Speaker for the House of Lords mercilessly mocked him to his face. This was the situation in which Edmund Burke, a member of the British Parliament from Ireland and a man regarded by many today as the father of conservatism, stood before the House of Commons and urged them to listen to what were at the time their countrymen in the New World. The general feeling among the members of Parliament was that Britain need only apply a firm hand and the colonists would eventually settle down. Edmund Burke disagreed. In his speech, Burke spoke of the character of the American colonists. He said, "In no country, perhaps in the world, is the law so general a study. The greater number of the deputies sent to Congress were lawyers. But all who read, and most do read, endeavor to obtain some smattering of that science. General Gage, who was the military governor of Massachusetts at the time appointed by the British Crown, General Gage states that all the people in his government are lawyers or smatterers in law, and that in Boston they have been enabled by successful chicane wholly to evade many parts of your capital penal institutions. Some of you will say that this knowledge ought to render them more clearly the rights of the legislature, their obligations of obedience, and the penalties of rebellion. But when great honors and great emoluments do not win over this knowledge to the service of the state, it is a formidable adversary to government. If the spirit be not tamed and broken by these happy measures, it is stubborn and litigious. This study renders men acute, inquisitive, dexterous, prompt in attack, ready in defense. This study, in other countries, the people, more simple and of a less mercurial cast, judge of an ill principle in government only by an actual grievance. Here they anticipate the evil and judge of the pressure of the grievance by the badness of principle. They augur misgovernment at a distance and snuff the approach of tyranny in every tainted breeze." Now, I won't give any spoilers about who turned out to be right about that. Now, the society that Edmund Burke, the father of conservatism, describes and praises is a litigious one. Was this a bad thing? King George certainly thought so. Whether good or bad, the founding fathers of this country saw litigation for their civil rights as the primary means of protecting their society. The quotation I just read is from March 1775. The situation went on for another year and a half of settlement efforts from the American colonists before they finally concluded that Great Britain had so mistreated her 13 colonies that they decided that it had rendered them free and independent states. This they proudly declared on July 4th, 1776. Before that momentous day, the founders had lived in a society where they were promised certain rights and liberties as British citizens. But those promises had turned out empty. They brought legal claims to enforce these rights, but their claims weren't heard. The men who brought them, like Benjamin Franklin, good men, were mocked and derided. Cries of rights and liberty were dismissed and treated as, at best, problems to be quickly dispensed with, and at worst, rebellious presumption in need of reprimand. So the Founding Fathers resolved never to let this happen again, and set in pen and ink the first, and still the finest, Constitution the world has ever known. In it, they proudly declared that we the people are the wellspring of political authority. This attitude pervaded the entire Constitutional Convention in 1787. Sometimes it took some getting used to. When Gouverneur Morris reacted with horror at the idea that somebody as lofty as the president could return to the general mass of the people, Benjamin Franklin, again, stood up and reminded him that ultimately that's actually a promotion because he's returning to his boss, the people of the United States. We the people are the ultimate bosses of government, and we would never again need to fear the arbitrary caprice of tyrants who would instead be subject to the law. We could point to our rights and we could tell them, this is how far you may come and no farther. In America, the law would be king, and that's the origin of our name, Lex Rex, which means the law is king. Well, how's that working out? Is arbitrary tyranny a thing of the past? Are our rights always upheld? Do we feel like we're in charge of government, or does it feel like it's the other way around? Well, did the Founding Fathers screw up? Well, let's look at the constitutional system they put in place. James Madison, in Federalist 51, famously declared that if men were angels, no government would be necessary. The framers of the Constitution understood that man's fallibility prevented them from having a government that could just do whatever it wanted. They needed to protect against it as best they could. Now, if you've ever taken a civics class, you've probably heard the phrase checks and balances. Under this theory, the different parts of our government keep the other parts accountable. The framers of our Constitution rightly assume that people tend to pursue their own self-interests. So by making the interests of each branch slightly different from the other branches, they could basically make them control one another. Let's look at a few of those checks and balances. One of them is the presidential veto on legislative action. Does that still happen? Yeah, it does. What about the Senate and the House? We have two different legislative bodies. And the Senate's appointed by the states, theoretically represents the states, and the House represents the people. Well, they still vote differently all the time, so clearly different interests are represented there. The court interprets the law. That still happens. If anything, that happens a little bit too much. The president still appoints justices. They're still confirmed by the Senate. Under the Constitution, the president controls the military and Congress funds the military. That way Congress can cut off funding if the president does something they don't want, and the president can direct the troops to do something that Congress might not want. That still goes on too. In fact, they're trying to do it all the time. Nomination still works with the president appointing high executive offices and Senate confirming them. Now, some of the more savvy among you are probably clawing at your seats right now because there's no doubt that many of these structural safeguards have been weakened over the years. But they're still fundamentally in place. So if our rights aren't being respected, who is it and what is it exactly that has failed? Well, the safeguard that I've overlooked until this point is actually the most important one. It's the one proudly declared in the very first sentence of the Constitution. We, the people. Under the Constitution, we, the people, are both the first and the final apparatus for holding the government accountable. On the front end, we do this by voting. As we've seen, that's seldom enough. We used to think that if we got the right guy in office, everything was going to go our way. But if we do, and even if he does manage to put the laws in place that we want, there's no guarantee that any of that's actually going to happen. Sometimes the executives in your state just don't feel like enforcing the law. That might sound a little bit familiar. And we've seen plenty of unelected bureaucrats do their own thing no matter what Congress or the president says. Heck, nowadays the fact that we the people voted for someone might not even be enough to get him into office in the first place. Now, I don't mean to downplay voting at all. It's an extremely important civic duty, but it's not the most important civic duty. We can have whatever laws we want on the books. If they aren't enforced, they do not matter. The primary check, the final safeguard that we the people have on the government, and the primary way that we've failed is the same thing that Edmund Burke talked about, the exercise of our legal right to hold public officials accountable when they abuse their power. Is this too much to expect from we the people? Were the founders just a bunch of Enlightenment thinkers overly optimistic about human potential? Not in the slightest. The founders were fully aware of what they were asking us to do. That's why Thomas Jefferson said that wherever the people are well informed, they can be trusted with their own government. That whenever things get so far wrong as to attract their notice, they may be relied upon to set them to rights. After framing our Constitution, a huge number of prominent founders, including Thomas Jefferson, James Madison, James Wilson, and John Jay, all dedicated their efforts to setting up institutions to educate the people and to make sure that they continued to know and to understand their Constitution. Moreover, they knew that it was possible because they'd seen it. Could what Edmund Burke said about the founding generation still be said today? Do we still have a society made up almost entirely of legal experts? Now, I can tell you, I run into lots of folks who think they're legal experts, but very few actually know a great deal about constitutional rights. The irony here is that being informed on the law is actually a lot easier than it was in 1785. And you might think that I'm talking about the internet here, but I'm actually not. Prior to the Constitution, the law was mostly made up of a series of very complicated and obscure common law rules built upon other complicated and obscure common law rules built upon other complicated and obscure common law rules. Studying the law required extensive study of thousands of cases written in arcane language. A lot of our law is still like that to some extent, but there's at least one thing that's nearly the opposite, and that's the Constitution of the United States. The Constitution was originally written on 4 sheets of paper. Sure, their paper was a lot bigger than ours, but it's still not a long read. You can finish it in an afternoon. I'm not going to ask for a show of hands, but how many here have actually read it cover to cover? I know Becky has. Moreover, any lawyer looking at our Constitution would notice a conspicuous absence of legal definitions, statutory language, and other obscure tools of the trade. Though it's perhaps dated a bit, it's written in plain English. It wasn't intended for some hieratic order of lawyers. It was written for we the people. The Constitution is our government's rule book, and we're the referees. What kind of referee doesn't know the rules of the game? That's step 1. Make sure that people know our Constitution. And the Lex Rex Institute offers services toward that end, including lectures and interactive educational resources for adults and children of all ages. Ask me more about it afterward if you're interested, or pick up our literature. Believe it or not, that's actually still not the most important safeguard of our constitutional rights, though. A referee who knows the rules counts for nothing if he doesn't enforce them. Today, we the people are very quick to point fingers at our elected officials for shirking their duties. But we're very slow to use the proper means of doing anything about that. We don't defend our liberties by complaining about things online or talking to them with our friends. We don't even defend our rights by voting. How do we enforce the rules of government? By doing exactly what our forefathers tried to do in 1775. We take it to court. Our Constitution explicitly protects the right of the people to have redress for wrongs against them. The right to sue for violations of our liberties has never been abrogated throughout our entire history, not once. It remains open to all. Now, you're not going to like this, but I speak to both liberal and conservative groups. And I can tell you that this is especially true of conservatives. By and large, conservatives are people who try not to make a fuss about things. We tend to view legal action as a way to make a quick buck at somebody else's expense. Those are usually good tendencies. I'm not criticizing those things. You're responsible citizens. And responsible citizens, in the interest of getting along with their neighbors, often let violations of their rights slide. They turn the other cheek. Often that's good. But when it comes to keeping the government in line, this can be based on some pretty severe misconceptions, especially some relating to the concept of judicial review, especially when it comes to what's often called judge-made law. What's really happening when the court decides to review a law that it finds unconstitutional is the court is saying that it lacks the power to enforce a particular law. When you sue for an unconstitutional law, what you're asking the court to do is to step up and say that this law isn't really the law. That's because the power of the court is limited. It can only act where the Constitution has authorized it to act. So when Congress passes a law that asks the court to do something beyond that, all the court can do is say, we're not allowed to do that. So you shouldn't think of it as trying to win concessions or to get a payback. Because we live in a system that regards very highly the ability of people to defend their rights, there are protections for people who do that, and you can get awards like attorney's fees or damages when people do violate your rights. You don't need to worry about being financially ruined just because you've defended your rights. But recovering a bunch of money is not our goal. While our system has very broad protections of the right to have grievances heard, that right is subject to a doctrine called standing. These rules can get a little bit technical, but especially when it comes to constitutional questions. But simply put, the person bringing a complaint has to be the person harmed by the conduct complained of. In most circumstances, you cannot stand up for the rights of another. A claim brought has to be your own. To me, as a lawyer, what this means is that I often spend a long, long time looking for a person with just the right kind of harm to make them ideally situated to challenge an unconstitutional law. But what it means for you, practically speaking, is that if you as conservatives are not standing up for your rights, nobody ends up standing for them. Everyone who ends up getting their day in court ends up being from the other side. Now, if I had a quarter for every time someone told me defending our rights in court has failed, I'd probably be a millionaire. But I don't want that quarter. What I want is for every time that you hear yourself saying that defending my rights has failed, examine whether or not that's actually true. Has someone actually tried to defend your rights in court? Very, very often the answer to that is no. Even more often the answer to that is, I don't know. If the answer is no, or I don't know, that's when to call a lawyer. There's a very good chance that they've been trying to defend this right, and they've been waiting for somebody in exactly your situation to be able to defend it. Now, unless you have a law degree, you're probably not going to know which issues can be litigated, and that's fine. But most attorneys can tell you in less than 5 minutes. Just call them up. They can give you a short consultation. In fact, the Lex Rex Institute offers free consultations for just that. But here's the important question. Can we actually win? Yes. We've done it. Often. I won't give you a rundown right now, but let me just add, the cases you hear about are only the cases that actually made it into court. And not just court, but usually got appealed several times and made it to the Supreme Court. What you don't hear about is every time someone threatened to sue and the person backed down immediately. The vast majority of my cases settle without a single document ever being filed in court. Many of the people violating your rights know that they're doing it. And they know that they have no legal ground to stand on. They back down as soon as there's a little bit of pressure put on them. Even more people in government just don't know what your rights are, and they don't know what the Constitution says. And the only way that they even know that they're violating the Constitution is when they receive a cease and desist letter. It takes most of my clients 1 day and maybe a couple $100 to cover my costs. And with that, they're able to exercise their rights in peace and play an integral part in upholding this beautiful system the founders have handed to us. Now, as much as you might like winning your Facebook arguments, that's not how you protect your rights. You protect your rights by getting the courts to recognize them. The Lex Rex Institute is here, and it's prepared to help you do just that. Even if you don't feel that your rights are currently threatened or aren't in a position to defend them right now, we ask that you consider contributing to LRI. Your contributions will be used to lighten the load of others bringing actions to defend their liberties and the liberties of all of us. America exists because people were willing to defend their rights within the legal means, and they founded a country where people wouldn't have to take up arms to do that. America will continue to exist as long as there are people willing to follow in their footsteps and stand up to government abuses. It's not easy. It's a lot easier when you have somebody in your corner. Our Constitution can be defended, and we're excited to do that. We hope that you'll join us.